right, good afternoon, everybody. Can I urge folks to take their seats and be at least not too disorderly? Welcome, welcome. I'm Deborah Raskin. I am president of the New York City Bar Association, and I am delighted to see you all here today. We appreciate your taking out time from your busy schedules to hear this program, which undoubtedly is going to be fascinating. We are so happy to be collaborating again with the Lawyers Committee for Civil Rights. Last year, our two organizations presented a program on the 50th anniversary of the Civil Rights Act of 1964. Today, we turn our attention to another major piece of legislation, the Voting Rights Act of 1965. And we are delighted as well to welcome the New York State Bar Association as a co-sponsor. The City Bar has been a staunch supporter of the voting rights law through various extensions and court decisions, some good, some not so good, including some not so good, Shelby County. Today is a particularly opportune time to consider what an accomplishment the Act was, how it has evolved, and where we go from here. And indeed, today, the Voting Rights Act is of even larger importance, given current efforts to stimulate greater voter participation by some and efforts by others to limit, discourage, or deny the right to vote. And so the struggle continues. We will hear today from people who were instrumental in the passage of the Act, as well as people who have been working to implement the Act and study its effect to its fullest potential. From the City Bar's perspective, there are few issues in the United States today more important than making sure that our nation's citizens can participate in electing their representatives, particularly with the outside influence of money in politics, encouraging and enabling as many eligible voters as possible to come out and to vote is hugely important. We desperately need an active and informed electorate making choices about who governs. The City Bar, over many years, has advocated any number of measures to stimulate voting, including Election Day registration, which we've supported, and we will continue to pursue meaningful reforms. But to make all of this work, we need the foundation of a strong and effective Voting Rights Act. And now I have two slightly inappropriate comments to make. One of which is when I was in high school about 15 or 20 years ago. Do you think that's funny? I was in a summer writing program, and Linda Greenhouse was my instructor, who struggled valiantly to teach me how to write. And since then, she's been teaching all of the rest of us how to write, so I'm really looking forward to hearing from her. And the second somewhat inappropriate comment is to urge all of you who are not members of the New York City Bar Association to join. You see what a lovely house we have, you see what fabulous work we do, and you see how very welcoming we are. And now it's my pleasure to turn the program over to the President-elect of the State Bar Association, Claire Goodekins.
Good afternoon. I will be extremely brief because you are here for the main event, and wow, is it going to be spectacular. But I just want to welcome everybody and say thanks for coming, as Deb said, for taking the time out. The State Bar has been committed to access to voting, access to justice in our society for a very long time. We most recently did have a committee on voter participation, and we've been supporting efforts to get the Voting Rights Act where it should be. And I also want to thank especially the panelists. I met our keynote speaker earlier, and how honored we are to be in their presence and to learn from their experiences. And I want to thank the City Bar for hosting in this magnificent space and the Lawyers Committee for doing the legwork to put this great program together. So welcome, everybody. Listen, learn from what we're going to hear, and then please take everything you learn back to your communities, to your organizations, and work with these great groups to make a difference and to help to make voting possible for everybody in our society, because it is really vital to our democracy and to the rule of law. So thank you. And I think next is John Nana, who is the co-chair of the Lawyers Committee.
Thank you, Claire. Thank you. And I want to note my co-chair is here early as well, Don Rosenberg, in the front row. First, I want to thank the New York City Bar Association for hosting this event, and also for hosting a wonderful event this morning with Judge Damon Keith of the Sixth Circuit Court of Appeals, a truly legendary jurist who broke many barriers while enduring racial discrimination himself. I also want to thank the New York State Bar Association for co-sponsoring this event. And by the way, I'm a proud member of both associations, and you've both been strong supporters of voting rights throughout the years. I want to thank Mr. Fred Gray, who's here, a legendary civil rights lawyer who joined us this morning as well and is going to be our keynote speaker this afternoon. I want to thank Linda Greenhouse when she arrives, and the rest of the panelists, all of whom are leaders in protecting the right to vote. Some of you may not be fully familiar with the Lawyers Committee on Civil Rights, so please let me share some thoughts with you for a few moments about how it was formed. The Lawyers Committee for Civil Rights Under Law was born in 1963 in the East Room of the White House. Judge Damon Keith was actually there for that birth. President Kennedy challenged lawyers and law firms throughout the country to fight for racial equality and for equal justice, to fulfill the promise of the Constitution, of the first few words, to establish justice. For over 50 years, the Lawyers Committee has been meeting that challenge. Much has been accomplished, but much is left to be done. The glass is only half full. Racial discrimination continues to permeate our society in new ways. We are blessed at the Lawyers Committee with a superbly dedicated staff, many of whom are here today, which has been led for 26 years by Barbara Unwine, our great executive director and president, a national civil rights leader in her own right. Our mission statement is simple. The principal mission of the Lawyers Committee for Civil Rights Under Law is to secure equal justice for all through the rule of law, targeting in particular the inequities confronting African Americans and other racial and ethnic minorities. One of the Lawyers Committee's most successful programs is our Voting Rights and Election Protection Program. We litigate voting rights cases and protect the vote through voter education, voter outreach, and assistance before and on Election Day. The link between racial equality and voting was well stated by President Lyndon Johnson when he signed the Voting Rights Act. The vote, he said, the vote is the most powerful instrument ever devised for breaking down injustice and destroying the terrible walls which imprison men because they are different from other men. It's bittersweet that we're here today commemorating the Voting Rights Act after a devastating decision by the Supreme Court in Shelby County v. Holder, gutting the most powerful tool in the Act for preventing voter suppression and the denial of the right to vote. I had the privilege of working with Lawyers Committee staff lawyers as co-counsel for one of the interveners, Bobby Lee Harris, in that case. I want to share with you an exchange from the oral argument. In asking a question that was really a speech, Justice Scalia called the Voting Rights Act, and I quote, the perpetuation of racial entitlement, unquote. How sad and how disrespectful to a Congress which reauthorized the Voting Rights Act based upon a mountain of evidence that the coverage formula was still valid. However, one of the other justices, a New Yorker, our own Sonia Sotomayor, shot right back and asked the counsel for Shelby County, sir, quote, sir, do you consider voting a racial entitlement, unquote? Thank you, Justice Sotomayor. I want to share with you one more personal experience that brought home to me the importance of the Voting Rights Act and why it meant so much to so many people. My wife and I attended the first inauguration of President Obama in 2009, and we were standing in front of the Capitol on that very cold morning, And we met a family that had traveled all night long from North Carolina to be there, a husband, a wife, and 2 small children. And the wife had brought with her grandmother's voting registration card in 1968. And she told us that her grandmother at the time was in her 70s. And 1968 was the first presidential election she got to vote in. Why? Because of the Voting Rights Act of 1965. Thanks. I will now turn the podium over to Kristen Clark from the Attorney General's office.
Good afternoon. It gives me great pleasure to join you all today on behalf of the New York State Attorney General's office to commemorate the 50th anniversary of the Voting Rights Act of 1965. I extend to you all greetings on behalf of New York State Attorney General Eric Schneiderman. I'd like to thank the Lawyers Committee and the City and State Bar Associations for organizing this truly historic event to commemorate what is by far our nation's most effective and robust federal civil rights statutes. No law has done more to transform our democracy or to bring about greater racial diversity in our halls of government. The Voting Rights Act helped create the conditions necessary to bring about the historic election and re-election of Barack Obama. But despite these achievements, we know that voting discrimination continues and that there is still real work to be done to achieve political equality for all. While many tend to focus on the work that the Act has done to address discrimination in the South, where the challenges have certainly been substantial, we know that the strong medicine provided by the Act remains equally necessary right here in New York State. Through our work at the Attorney General's office, we know that voters encounter barriers today on the basis of their race, national origin, their language, and their disability status. Moreover, in New York, voter turnout ranked 44th in the country during the last presidential election and 49th in the country during the most recent 2014 midterm election cycle, with only 29% of eligible voters in our state turning out to cast a ballot. Powerful reforms are necessary to help transform and modernize the election system in our state, including same-day registration, no excuse absentee voting, and more online registration opportunities. I look forward to hearing the insights of our panelists on these issues later in the program. I want to turn the floor over now to Barbara Arnwine, President and Executive Director of the Lawyers Committee for Civil Rights under Law, who is retiring after more than 2 decades of extraordinary service. Barbara's been a powerful voice and tireless advocate on behalf of voting rights and civil rights issues throughout the years and across our country. And I just want to thank you, Barbara, for all that you have done to champion the rights of disenfranchised persons across our nation. Barbara Arnwine.
Good afternoon, everyone. What a pleasure it is to be here today. I want to also extend the thanks of the Lawyers Committee to the Association of the Bar of the City of New York for co-sponsoring this very, very important forum and for having this event here at the home office. I want to also thank all the members of the board of the Lawyers Committee, many who have traveled across the country to be with us tonight. I want to thank our staff. I want to thank all our friends and the many advocates who are in the audience for being here this evening. I have a great pleasure today and to introduce the veteran civil rights attorney and champion, Fred Gray. I do want to note that I will have to leave the program early today. Fred, I will get to hear your magnificent address. But the work of voting rights is the work that we have to do in so many forums. And MSNBC called me and said they want me to come on tonight at 6:30 and talk about voting rights. So I will be on national TV discussing these issues in very short order. So it is clear that part of the work that we do around voting rights is the multifaceted battle to preserve the important ability of all citizens to exercise the right to vote. In talking about that right to vote, you have to talk about Fred Gray. Dr. Martin Luther King Jr. once described Gray as, quote, the brilliant chief counsel for the protest movement, unquote. Today, we are so honored that he has joined us to kick off the annual A. Leon Higginbotham Corporate Leadership Awards dinner by celebrating the upcoming 50th anniversary of the Voting Rights Act of 1965. Fred Gray was born in Montgomery, Alabama in 1930 and became an ordained Christian minister as a teenager. He graduated from the Alabama State College for Negroes in 1951 and earned a law degree from Case Western Reserve University in 1954. He wasted no time in returning to Montgomery as a sole practitioner, vowing to, quote, begin destroying everything segregated. What a great vow, and what a blessing to all of us, because you can all appreciate the tremendous ambition and bravery of Gray's objective in the pre-Civil Rights Act, Alabama. At 24 years old and less than 1 year into his legal career, Gray filed the federal case Browder versus Yale. He defended Claudette Colvin, Rosa Parks, and 3 other plaintiffs against charges of disorderly conduct for refusing to give up their seats to white passengers on the city buses. These women's bravery and Gray's case catalyzed the Montgomery bus boycotts, which led to one of the budding civil rights movement's major victories on December 20th of 1956, when the United States Supreme Court held that racial segregation on public transportation was unconstitutional, setting the groundwork for so many cases to come. Gray was also Dr. King's lawyer in every respect. Dr. King once told him, quote, Fred, if we are arrested, we will be calling on you to defend us, unquote. And he was a tireless defender. Fred filed and won a storm of lawsuits in the 1960s, including 2 separate cases that desegregated the University of Alabama and Auburn University, as well as NAACP versus State of Alabama, in which Gray defended the NAACP's right to continue its work in that state. His docket is legendary. And we would be remiss to reflect upon the recent 50th anniversary of Bloody Sunday, or to commemorate the upcoming 50th anniversary of the landmark Voting Rights Act without celebrating Gray. You should know, Fred, that on March 6th through the 9th, the Lawyers Committee sent an 83-person delegation to Selma, Alabama, composed of our board, our staff, the Chicago Lawyers Committee staff, 4 other organizations and friends. And when we walked on that bridge, there's one thing that will never, ever escape my imagination and my spirit. That is when you crest that bridge and you look down that hill and you see that those people, that 600 brave people led by John Lewis, that when they got to that crest and they looked down there and they saw the dogs and they saw the horses and they saw the batons, the whips, and the threat to their lives that the Alabama State Troopers had, I will never, ever forget that they kept marching. And that's what your spirit has been. You have kept marching over and over in so many cases. Think about this. He argued Gomillion versus Lightfoot, in which the court held that the Alabama legislature's drawing of electoral district boundaries in Tuskegee effectively disenfranchised African Americans in violation of the 15th Amendment and intentionally deprived black citizens of political power. This historic case was later cited in Baker versus Carr, which established the one man, one vote principle of the Equal Protection Clause, which incidentally the court is going to revisit this coming term. Gray also represented the brave participants of the Selma to Montgomery March that led to the passage of the Voting Rights Act. After numerous victories in the 60s, of course, Gray wasn't finished. He went on to win one of the landmark cases that we all know as the Tuskegee syphilis study. He was one of the first African Americans elected to the Alabama state legislature in the post-Reconstruction era. In 1985, he became president of the National Bar Association, and in the 1990s, he created the Tuskegee Human and Civil Rights Multicultural Center and authored 2 books entitled Bus Ride to Justice and Tuskegee Syphilis Study. His work has been recognized with the American Bar Association's Equal Justice Award, among other awards, and he was elected president of the Alabama Bar Association in 2001. Gray once revealed in an interview that for 35 years he told no one about his commitment to destroy segregation. You see, without eagle or flash, and without the instant fame of modern-day media, with quiet dignity and grace, Gray has executed his secret pledge. His work inspires me, as it should inspire every attorney and activist, to move America towards justice, not for prestige, but out of conviction that this work remains essential, fundamental, critical. So please share my warmth, admiration, enthusiasm in welcoming our keynote speaker, the legendary Fred Gray.
What do you say when you've had an introduction like that? Thank you so much, Madam President and Barbara. Not only do I thank you for those kind words of introduction, but I thank you for the leadership that you have given this organization during these many years of its existence. And I didn't know until I arrived that you were about to go on to even greater heights. And I want to simply say to you, Barbara, thank you so much for all you've done. Let's give your president a hand. To the officials of the Lawyers Committee on Civil Rights, on the law, the officials of the New York City Bar Association and the New York State Bar Association, the members of the judiciary who may be present, elected and appointed officials, fellow panelists, and ladies and gentlemen. I have some special guests who are here this evening that I want to first introduce to you. One of my clients that I had the privilege of representing in desegregating Florence State University, now the University of North Alabama, Wendell Gunn is here someplace. And thank you, Wendell, for coming. He also went on to become a member of the Reagan administration, and he lives in the New York area, and we are happy that he's here. I'm glad also to have with us Karen Gray Houston, who is my niece. I also have Maddie Thompson, who's here, who is a cousin of mine. I was named after her father. I think there is also, oh yes, my wife's niece is here, Celine Moore. I'm going to miss somebody, I'm sure, but greatest of all, I'm happy to have my wife Carol, who's here. Not only because she is my wife, but when I lost my first wife after 40 years, she said she wanted the responsibility of taking care of me. And for the last 14 years, she has done that. And guess what? She has a birthday today. Let's give Carol a hand. There is also in this audience a great lawyer from New York who's done a lot of civil rights work, Joe Watley. Joe Watley is here. I'm happy to have Joe. He's on his way down to Alabama. His father, his uncle, was a Methodist preacher in Montgomery during the bus boycott. He was sympathetic to our movement, and he was run out of town. And they're going to be in Tuskegee and in Montgomery on Friday. And when he called me last week, I told him I was going to be here, and I'm just happy that he was able to come. So thank all of you. And those other special guests who may be here, who have been invited, I want you to know I'm appreciative for your presence, too. I wish to thank Ms. Karen Miller, who extended to me on behalf of these groups the invitation to come and to speak to you today. There was something she told me and something she didn't tell me. She told me that she was extending this invitation to be the guest speaker. And you know, for a civil rights lawyer from the cradle of the Confederacy and living now in rural Macon County, Alabama, to be invited to New York City to do anything is an honor. And I am appreciative for all of that. But in Ms. Miller's invitation, she told me that we, referring to these groups, commemorate the 50th anniversary of the Voting Rights Act of 1965 and host a panel discussion on the transformative impact of this groundbreaking law in ensuring that all Americans have a voice in democracy. She continued to say, given my experience, she wanted me to serve as the keynote speaker for this occasion. Then she proceeded to tell me what to talk about. And I'm quoting what she told me. We would like for you to set the table for the discussion by discussing the environment surrounding the enactment of the Voting Rights Act of 1965 and what current lessons can be drawn from that experience. Now, that's a big task. And if I'm going to do justice, what she didn't tell me until today is that I have 30 minutes to do it in. I'll try. This event is labeled the destiny of democracy we shall overcome. To appropriately discuss that topic, I must go back to the beginning of this nation and look at the documents upon which democracy is based. The basic documents upon which this nation are based are the Magna Carta, the Declaration of Rights and Grievances, the Declaration of Independence, and the Constitution of the United States of America and the amendments thereto. Now, the origin of law as set forth in those documents deals with the rights of white Englishmen and white Americans. You may not realize it. We the people, as stated in the preamble to the Constitution of the United States, did not include people who look like me. It did not include and did not seek to protect the rights of African Americans. The drawers of the Magna Carta, the Declaration of Rights and Grievances, the Declaration of Independence, and the Constitution of the United States, as they became effective in March of 1798, were only concerned with the right, were not concerned at all about the rights of blacks. The rights of African Americans were not their concerns. Therefore, it became necessary to adopt the amendments to the Constitution of the United States and to pass laws in order for African Americans to have rights. One of such laws that was enacted by Congress is the Voting Rights Act of 1965, which we celebrate here today. However, on December the 18th, 1865, the 13th Amendment was passed, abolishing slavery. July 28th of 1868, the 14th Amendment was passed, giving African Americans the right to be citizens. And while that amendment was adopted primarily for the right of African Americans, now it protects more whites' rights than it does blacks because there are more of them. And then in March 30th of 1870, the 15th Amendment giving us the right to vote. That should have ended the question as far as voting rights for African Americans, but it was not the end. It really was just the beginning. But I want you to know that for the last 6 years, I have devoted my time and my effort toward doing away with and making it possible so that African Americans could have the same rights in this country that whites has. I'm not one of those lawyers who always wanted to be a lawyer. When I came along in Alabama, there were about 2 per session. Then somebody reminded me to day 3, but I told them I didn't want to think about the other one. And that was basically a young man could be a preacher and could be a teacher, and you did them both on a segregated basis. I'd learned a little something about preaching, and I went back to home, to school, and lived on the west side of Montgomery in Alabama State. The historical black school was on the east side, and I had to use the transportation system. And I found that our people were being mistreated on the buses. And I found that everything in Montgomery at the time was completely segregated. And that was in 1947 when I came back to go to school. I made a secret commitment that I didn't tell anybody about for about 40 years. And I think it's the best thing I ever did, was keep it secret. I said, I'm going to finish state. I'm going to go to somebody's law school, not even apply to the University of Alabama because I know they won't let me in. Finish law school, come back to Alabama, pass the bar exam, become a lawyer, and destroy everything segregated I could find. That was my commitment as a teenager. And that was my commitment in 1950. And I am glad that the President of the United States, President Kennedy, 13 years later in 1963, saw the same need for lawyers and formed this committee. And I want to thank you for the work that you have done, because I was doing that same work 13 years before and still doing it. So give yourselves a hand for what you've been doing. Now, I've been just reminded that my time is running, so I'm going to have to cut a lot of this off. But it's hard to cover 400 years in 30 minutes. But I want you to understand, however, that the wrong to be corrected. And the reason this committee was set up was to correct those wrongs. And the reason I became a lawyer 13 years earlier was to correct those wrongs. Even in the field of education, and I probably have filed as many lawsuits as anybody to do away with discrimination in education, you would think that discrimination, the first case dealing with it, would have been in the South. But it wasn't. It was in Boston, Massachusetts. Sarah Roberts. When the Boston court held in 1850 that Boston could segregate students based on race. That was one of the problems that had to be solved. Then you had the Dred Scott decision in 1857, which in effect held that a black person was not a member of the community, was not a citizen, and could not file a lawsuit in a federal court. And that case generally has become known as being one that says a black man has no rights that a white man has to respect. Then there was the unhappy days between 1861 and 1865 when Congress specifically passed laws providing for segregation of schools in the District of Columbia. So what I'm saying is that we had all of these laws, and these are all wrongs that had to be corrected, and which the Voting Rights Act seeks to correct. You can't talk about Voting Rights Act or voting rights, and you can't talk about Selma, and you can't talk about the Voting Rights Act of 65 without first saying a little something about the Montgomery bus boycott. Because the Montgomery bus boycott was the first time you were able to get over 40,000 African Americans to come together and decide that we have a problem. Our problem is with buses. And while we were concerned, and I don't have time to go into it, about having Mrs. Parks acquitted, we wanted to do more than that. We wanted to get the laws declared unconstitutional, and we wanted to get a mass participation in it. The first time in the history of this nation, the Montgomery bus boycott that started with Mrs. Parks' arrest, and actually the first person who, my client, was Claudette Carvin, who did the same thing she did and did it 6 months earlier. And I thought I was going to have Claude up here. She lives in the Bronx. But in the last minute, she ended up telling me she was unable to make it. But what I want you to understand is there were a series of events that occurred, and it didn't just happen. Just like this organization, the Committee for Civil Rights, didn't just happen. The Montgomery bus boycott didn't just happen. There was a series of events occurred over about a 28-month period from the time I was licensed to practice law on the 7th of September, 1954, through the end of the bus boycott. And some of them were these. 6 weeks after I became a lawyer, Martin Luther King became pastor of Dexter Avenue Baptist Church. 6 months later, Claudette Carvin did what she did. 6 months after that, Rosa Parks did what she did. 6 weeks before Rosa Parks did what she did, Frank M. Johnson became district judge in Alabama. I filed the case of Browder versus Yale on the 2nd of March, 1955. So what I am saying to you is there was a series of events which came into existence over a period of about 22 months. And I believe there was a little divine intervention involved in it. Looking back over these years later, because during these 27 months and 2 weeks that passed, all of those things came together and made it possible so that there could be a Selma to Montgomery march and ultimately a Voting Rights Act of 1965. I want you to also understand it wasn't an accident that Bloody Sunday occurred in Selma. It was no accident that it occurred in the state of Alabama. And it was no accident that because of what took place there, that bill would pass. But let me tell you one other thing. You cannot discuss the matter of African Americans obtaining the right to vote without talking about the residents of Tuskegee and Macon County, Alabama, because the first voting right cases, long before Selma, long before Birmingham, long before Montgomery, residents of Macon County, Tuskegee, Alabama, was filing lawsuits for the right to vote. On August 25th, 1945, a class action suit was filed in the federal court. Mr. Marshall and Arthur Shores, the legendary lawyer in Birmingham, who was there long before I came, filed it. At the same time in Alabama, with encouragement from the leadership in Macon County, 25 lawsuits was filed in state courts appealing African Americans' right to vote. Then in 1953, local residents from Tuskegee filed another court in federal court. In February 1957, 6 months before the Civil Rights Act of 1957 was passed, Dr. Gomillion and others testified and submitted to the Justice Department evidence that was used so that that act could be passed. And I'm happy to say that I was one of the persons involved in giving that testimony and helping Dr. Gomillion get it together. For it was the testimony that was submitted in February 19th that was used to help pass the Civil Rights Act that came into existence in September of 1957. So then, there are a couple of other things I'm just going to mention about Tuskegee because you have to, and there's so much history there. There's been some talk, and Madam President mentioned about Gomillion versus Lightfoot. In Tuskegee, when we finally was able to get a few people registered to vote in 1957, and a municipal election was coming up, not enough to elect a black, but enough to make a difference in the election, a bill was passed in the Alabama legislature changing the city limits of Tuskegee from a square to 28 sides. And then they say, we're not denying you the right to vote. You can vote in county elections, state elections, federal elections. You just can't vote in the city election, not because of your race, because you don't live in the city. It was a tough case. Nobody thought I could win it. But I was able to get Robert Carter, who had also worked with me, and Thurgood Marshall and all the work during the bus boycott. And we ended up, Judge Johnson ruled against me, the Fifth Circuit ruled against me, but we were able to win it unanimously in the Supreme Court. Tuskegee was the only place almost in Alabama where you could have a meeting of people on an integrated basis and not have fear of it. It was on the campus of Tuskegee when Dr. Bernard Lafayette was sent by Southern Christian Leadership Conference to go to Selma to make plans for the Selma activity. Before he went there, he came to Tuskegee. And he went to the library, and he did his work because he knew that all these activities had occurred in Tuskegee, and it prepared him to be able to assist in making the plans for the Selma to Montgomery March. And while he was there, he met a young lady, Kate Bull, and ended up marrying a girl from Tuskegee. But there's so much history there. As you know, wasn't a lawsuit, but the whole business of the Tuskegee Airmen started in Tuskegee. Then when you have all these good things to start, you also have bad things to start. You have the Tuskegee, the federal government ended up with the syphilis study. When I'm trying to end up filing lawsuits against the state and the cities and the county, and then all of a sudden I woke up one day and found out the federal government was involved in a deadly deception many African American laws. So that history is there. And then in Tuskegee, believe it or not, it has been a battleground for other precedent-setting cases. The right for African Americans to serve on juries was a case I filed there. This past year, there have been millions of dollars distributed to black farmers throughout the Black Belt. I filed the first case in 1958. Didn't get any money for it, but it set the precedent that held that the federal government should not discriminate in farm subsidy cases. Then I've talked with you about the Tuskegee syphilis study and all of these matters. So when you talk about, and also one of the persons who were beaten back on Bloody Sunday was Mrs. Amelia Borington. She was a graduate of Tuskegee, she and her husband. So then, so much history has occurred in Tuskegee until we decided in 1995, or in the early 90s, we concluded that nobody then was preserving the history. So we started the Tuskegee Human and Civil Rights Multicultural Center. We want you to support that center. We want you to come and see it. We have some little brochures that those of you who are interested in it will be able to see. Because if we go into all the work that we're doing and all the work this committee is doing, unless it's preserved, we have two whole generation of people who know nothing at all about civil rights. And if we don't preserve it so that they can see it and participate in it, there'll come a time and we won't even know it. Let me just tell you briefly, there was a period of time from 1957 to 1965. That's a very important period of time, too. That's from the end of the civil rights, from the end of the Montgomery bus boycott until the Selma to Montgomery March. But all of these events that occurred made it possible for the Voting Rights Act and for the passage of that act. In 1957, after Dr. King we had finished the Montgomery bus boycott, he started the Southern Christian Leadership Conference. The primary purpose of the Southern Christian Leadership Conference was to lead the civil rights movement in the South. And it was that conference, and it was Dr. King's effort there, that the movie Selma was all about. And while I don't have much time to last, I'm going to have to save a little bit of time to tell you a little about Selma, because the role that lawyers played in Selma was very important, because it's the same role that this organization has been doing since its existence. I want to mention one other thing, and most people don't realize this. And if in 1960, the state of Alabama, after Dr. King had left Alabama, decided to bring a suit against him, get an indictment against him for perjury in connection with his taxes in Alabama in 55, 56, and 57, and 58. If at that time, he's now an international figure, he was speaking out against the Vietnam War, if he had been convicted, it could have made a real difference in everything that took place. I was a part of a team that ended up trying his case in the middle of the civil rights movement, in the middle of sit-in demonstrations in Montgomery, and all-white jury found him not guilty. And for that to happen in Montgomery at that time enabled him then to go on to Selma and Albany and the other places that he went. In that intervening years, you had the sit-in demonstrations, you had the freedom riots, and you had the freedom and the demonstrations by the kids at A&T that resulted in the passage of the Public Accommodation Act. All of these things led the way for the Selma to Montgomery March. Now, let me tell you a little something about the role the lawyers played in Selma. How many of you have seen the movie Selma? That's good. How many of you saw that part of the movie, the second part of it? You saw them beaten. You know all about that, and I'm not going to talk about that, but only to tell you a little something in a minute. When they were beaten back on Bloody Sunday, I got a call from John Lewis and Mrs. Warrington and Jose Williams, and I knew all of them, telling me they had been beaten back. They thought they had a constitutional right to do what they were doing, but they didn't want to be beaten. They asked me that Sunday evening to come across that bridge with all those state troopers out there to talk to them. And you know what I did? I did it. Not only that, they told me that they wanted me to file a lawsuit. I got back in my car after getting facts from them, called my staff that night. We worked the rest of Sunday night, and before the close of day on Monday, the 8th, we filed the case of Williams and others versus Wallace and others. Now, that case occurred, and you saw the beating. Then you saw the time. And it doesn't tell you anything, but you saw the state troopers, and you saw Dr. King wasn't there the first time, but he was there the second time, and you saw him come up. Then you saw the state troopers disappear. Then what happened? Then Dr. King turned around. What the movie don't tell you is why they turn around. Do you know why they turn around? The lawsuit that I filed on the 8th, the governor knew about it, the state troopers knew about it, and they knew that anything they did that night or that day would end up being in court the next day, on that Thursday, because Judge Johnson had set a hearing for Thursday, and this is Tuesday. But there's another part you don't know either, and I'm going to tell you that because it's important. After I filed the case on Monday, I got a phone call from Judge Johnson on Tuesday. And when these federal judges call you, and I went over there, and he looked over his glasses and said, Mr. Gray, you filed a lawsuit in this court saying your client's constitutional rights have been violated. And he says if they've been violated, the court's going to grant relief. If not, I'm not. He said, but I have heard, and judges don't usually talk about what they've heard, He said, I have heard that your clients are going to march anyway. And he says, I have issued an injunction enjoining them from marching. And I tried to tell the judge, you don't understand the people in the movement. He said, Mr. Gray, you're an officer of the court. Control your clients. And he excused me. I went to Selma. I found Dr. King. I told him about my conversation. I got a commitment from him. I said, now, I know you got a lot of things to do, but I want you to understand, don't violate that order because you're going to be served with a copy of it later on. And the issue involved here is far more important. The judge has set the hearing for Thursday. That's right around the corner. I got a commitment from Dr. King, and that commitment was, I'm not going to violate the judge's order. I didn't care how he did it. I went ahead and got my case ready. So what I am saying to you, and I'm being told that I have 2 minutes, and I'm going to take a little longer than 2. But what happened is, it was the lawsuit that made the difference. The state troopers knew the lawsuit was filed. Dr. King knew the lawsuit was filed. That while today we end up celebrating 50th anniversary of the passage of the Voting Rights Act, we also represent 50th anniversary, or we celebrate 50th anniversary of those people who were beaten. But in addition to that, we celebrate 50th anniversary of the filing of Williams versus Wallace. And if that lawsuit had not been filed, there would have been no march because George Wallace wasn't going to let it take place, and there would not have been a passage of a Voting Rights Act of 1965. Now you know the rest of the story. I was supposed to tell you a little something about where we go from here, and I must hurry, and I know that. But I want you to understand, as we sit here today, the question arises, where do we go from here? We know the problems that are involved, and this panel is going to come and talk with you about them. But I want to leave with you at least what I think we need to do at this point. And the challenge is yours. What does what I have discussed with you today mean to those of us participating in this forum in New York on June 3rd? It means the struggle continues for equal justice under the law. Finally, so that we may have an impact both in America and worldwide, I suggest 4 things that I think we need to do. 1, we need to recognize that racism is alive and well in this country, and it's wrong. The declaration needs to come from the top. If the heads of our law firms, our institutions of higher learning, the CEOs of corporations, and if the heads of our cities and our counties and our states and our federal government will come out with a loud voice saying that racism is wrong, that will be the first step. This nation has never really completely faced up to the real solving the race problem. Secondly, it's not going to go away by itself. It hasn't gone away by over 400 years. The bus boycott didn't start by itself. The Selma to Montgomery March didn't start by itself. This committee didn't begin by itself. It took plans. If we're going to do away with racism in this country, you're going to have to come up with a plan, and you're going to have that plan, a workable plan. But you know what? A plan is no good unless you implement it. So the third thing is the implementation of a plan to do away with racism in this country. And along with racism goes everything else that deals with it. And then the last thing, all of us, we would like to wake up one day with all these problems are solved and we don't have any, everybody's going to be treated freely, but we want somebody else to solve the problem. If the race problem in this country is going to ever be solved, you must do your part individually to eradicate racism. You can, if you will. First, acknowledge that racism is a problem, because if we don't think it's a problem, then it won't be solved. 2, you need a plan. 3, it needs to be implemented. 4, you and everybody else will need to do our part. I have shared with you some of my experiences and made some personal suggestions about what I believe we need to do to complete the struggle for equal justice. I now leave it up to the panel to come and give you the details, because they are the experts. Thank you very much.
Thank you, Mr. Gray. I'm Don Rosenberg. I'm the other co-chair of the Lawyers Committee for Civil Rights Under Law. And we're going to begin the panel discussion shortly, but I wanted to make a brief introduction. In her February 20th, 2013 New York Times column, Pulitzer Prize-winning journalist Linda Greenhouse asked a powerful question that is still relevant over 2 years later. Quote, how can it be that one of the crowning achievements of the civil rights movement, a law that has demonstrably defeated myriad efforts, both flagrant and subtle, to suppress or dilute the African American vote, is now hanging by a thread, close quote. Ms. Greenhouse, of course, was referring to the Supreme Court's decision to hear Shelby County versus Holder, a case challenging the constitutionality of the preclearance provision of the Voting Rights Act of 1965. Today, we are honored to have the acclaimed Ms. Greenhouse moderate our panel commemorating the Voting Rights Act, which we, of course, are fighting to restore, and highlighting its palpable impact. Ms. Greenhouse is a graduate of Harvard University's Radcliffe College and earned a Master of Studies in Law degree from Yale Law School. She is now the Knight Distinguished Journalist in Residence and Joseph Goldstein Lecturer in Law at Yale Law School. She covered the Supreme Court for the New York Times between 1978 and 2008, and currently writes a biweekly column on law topics, including voting rights, marriage equality, and criminal justice. She's been recognized and awarded by the American Law Institute and the American Philosophical Society. She is a fellow of the American Academy of Arts and Sciences and a national board member of the American Constitution Society. Ms. Greenhouse is also author of 2 books, the most recent of which is titled The U.S. Supreme Court, A Very Short Introduction. She is the co-author of a 3rd book exploring the cultural, political, and legal debate preceding Roe v. Wade. Ms. Greenhouse's ability to ask thought-provoking questions, her extensive knowledge of the court, and her knack for objectively approaching complex subjects make her the obvious choice to moderate today's panel. Please help me in welcoming Linda Greenhouse.
It's an honor and privilege for me to be here and to have heard Fred Gray. I only wish I could name 5 justices of the Supreme Court who dearly need to learn a little bit of that history that you said people haven't learned. It's just kind of heartbreaking to hear an account of the days when one could turn to the Supreme Court and expect justice to be done there on these issues. So this is incredibly timely. And as I say, it's just an honor for me to be among people that have devoted their lives to expanding notions of equality and justice. So I'm not going to take the time to give real introductions to our panelists. You have the program, so I'll just, or I guess you see their name tags, so I'll just run down quickly who they are, because I don't actually know them, so I have to guess who they are. But Wayne Dawkins, that's Wayne Dawkins, longtime journalist, currently teaching at Hampton University. Myrna Pérez is Deputy Director of the Brennan Center's Democracy Program, and I'm on the Brennan Center's email list, and I just got an email today giving the scope of the number of vote suppression measures that the various states have passed in the last couple of years, and it makes chilling reading that Brennan Center's really doing great work. Marcia Johnson Blanco is Marcia. My contact here, co-director of the Voting Rights Project of the Lawyers Committee. Eric Rodriguez from National Council of La Raza, and Janai Nelson, Associate Director-Counsel of the Legal Defense Fund. So we had worked out a nice little plan of my tossing a series of questions at the panelists, and right after we worked out that plan, the court noted jurisdiction last week, as I'm sure most of you know, in an extremely important, extremely troubling case from Texas, Evenwell against Abbott, which is a challenge to the use of raw population in redistricting, and it's a claim that districting that counts those who are not eligible to vote actually serves to dilute the votes unconstitutionally of citizen voters. This is a very cynical piece of litigation that has now reached the court. It's brought to us by the same team that brought us Shelby County and that currently is seeking cert once again in Fisher against University of Texas. So this is something to be taken extremely seriously. And so before we get into what I had planned to ask our panelists, I just thought I would toss out and invite any of you to talk a little bit about the implications of this case, which is a threat not only to basic principles of one person, one vote, as we've come to understand them, but also very deliberately and very cynically poses a constitutional challenge to Section 2 of the Voting Rights Act. So can I just ask whoever wants to weigh in? Myrna, you want to start?
Thank you so much for having me. What Ms. Greenhouse didn't mention was that I'm a former chair of the New York City Bar Association's Election Law Committee, so it's good to be home. This law this particular case has a number of implications. One of the ones we're most concerned about is what it could do to Latino voters and Latino communities by messing with or distorting or changing the way districts are formed on the basis of population. We have a very real propensity for there to be fewer districts in which Latino communities can elect their candidate of choice. Moreover, depending on the scope of the case, Latinos could get a double whammy because not only may they have their adult population be diminished because of a assessment as to who is citizens and who's not citizens, Latinos tend to have a large number of children. So if you are examining and deciding that districts are going to be drawn on the basis of citizen voting age population, not only is that going to make communities like Latinos who have blended families, so not everyone in their community are going to be full citizens, but also have a large number of children, so they could get two kinds of attacks and two kinds of ways of diminishing their political power and making it harder for them to get the kind of representation that they need in order to make the very basic details and aspects of their life comfortable and equal to what most Americans are able to enjoy.
And tell me if I'm being alarmist about this, but having read the briefs at the jurisdictional stage of this case, one argument that's being made is that to the extent that Section 2 of the Voting Rights Act would seek to preserve the voting strength of Latinos, that Section 2, in conflict with the theory of population that's being put forward in this case, would be unconstitutional. Has anybody picked up on this?
I'd be happy to weigh in on that. So I want to back up a little bit. I'm not sure if everyone really is fully familiar with this case and what it really means. Fred Gray delighted us with his story about his litigating Gamillion versus Lightfoot. That was the precursor to the one-person, one-vote rule, which means that when you're drawing electoral districts, they need to generally be equal in population. That is the fairest way to draw districts and make sure that everyone has equal representation. What this case does is challenge who should be counted when you are drawing those districts. And up until this point, we've counted everyone, right? Everyone deserves representation, whether they vote or not, right? Our country was founded on the principle of no taxation without representation. It wasn't qualified upon whether you voted or not, whether you were eligible to vote or not. So in this particular challenge, the concern is whether we should now limit it to people who are eligible to vote, citizens who are 18 years old and above, who don't have any mental incapacitation and do not have a record of a felony. That narrows the pool of people who would be counted in these electoral districts rather considerably. So the concern and tension potentially with Section 2 of the Voting Rights Act is that there are different ways that we count voters for purposes of majority-minority districts. But it's for a very particular reason. And that reason is, under Section 2 of the Voting Rights Act, you have to demonstrate that there is an ability to elect in order to construct a majority-minority district. You have to show that we're not just asking for a district just to have one and we can, in fact, use it to elect an official. You have to show that there's some real relief that can be obtained by constructing a district that's predominantly majority minority, Black or Latino or even Asian in certain cases. And so that's, in those cases, we rely on citizen voting age population. We rely on the much narrower group. In this case, though, when we're talking about dividing up electoral districts as a general matter, to suggest that we do not continue to follow the one-person, one-vote principle by using the broadest definition of the population violates our general constitutional principles. In our Constitution, when we apportion representatives for Congress, the House, we use general population to do so. We don't look only to voters. If you look at Section 2 of the 14th Amendment, it's very clear that when we're thinking about how we apportion representatives, we look at the entire population. There's still some dirty language in there about Native Americans, but if we put that to one side, what we see is a very inclusive principle. And this case really should not be seen any differently than that, and it should not have any effect on Section 2.
So,
well, can I just add a couple of things? I mean, I think it's important also to keep in mind the scope of the issue as we see it. I'm sorry, as close as I can get. The first thing is that if you look at demographic data over time, we're certainly seeing that by 2044, 14 states up from 3 will be majority-minority. Right now, so there's vast demographic change. This is happening in a number of key states faster than in other places. Today, we have 12.5 million Latinos that are registered to vote. We have 10 million, however, that are eligible but not registered to vote for a variety of reasons. And that's highly problematic when we're talking about these issues. 900,000 Latinos will turn 18 and be eligible to register each year for the next 15 years. So as long as these barriers continue to hold and these kinds of issues come before the courts, we are very, very concerned about what this will mean for the country.
I'll just make one more comment before we move on to our other topics, which is that this issue has been litigated for the last 25 years or so. and the court has not previously engaged with it. Every court that's looked at the issue has said one thing or another, but basically we leave it to the states, and the states are using population, and that's their right to do that. That's what the three-judge court did here in upholding the way that Texas counts the full population. So the Supreme Court really had no reason to swoop in. I mean, yes, it was a jurisdictional statement, not a petition for cert, but they simply should have affirmed the holding of the three-judge court. So it's just very concerning that here, coming up on the second anniversary of Shelby County against Holder, we have the next chapter. And speaking of Shelby County, I will turn to Janai Nelson and ask her to talk a bit about the Janai Nelson. Oh, Marcia, you're going to do? Or I have you mixed up. Okay. So whoever is going to talk about Shelby County, we can all talk for a long time about Shelby County. But the implications of the decision, the impact, and what might be the remaining role for what's left of the Voting Rights Act in addressing some of these issues that used to be addressable under Section 5.
Sure, I'd be delighted to talk about that. We jumped right into the Supreme Court case. I do want to just extend my thanks to the Lawyers Committee and the Bar Association for inviting me to participate. We at the Legal Defense Fund have such a strong connection to the Voting Rights Act. We were privileged enough to litigate with Fred Gray the Wallace, the Williams versus Wallace order, Thurgood Marshall, Robert Carter, Steve Ralston, Benjamin Solomon Say, many of our attorneys who were the founders of our organization in many instances were part of this struggle from the very beginning. So I am really honored to be part of a discussion that involves Mr. Gray and an organization that has been our partner for such a long time in the fight around voting rights. The Shelby County decision was nothing short of devastating to the civil rights community and to anyone who really cares about progress in our democracy. This decision happened June 25th, 2013, so we're coming up, as you said, on a second-year anniversary. And effectively what it did was take away a pre-clearance measure from the Voting Rights Act. The Voting Rights Act expanded voting opportunities for minority voters across the country by barring poll taxes, by barring literacy tests, by barring all sorts of mechanisms that were previously used to prohibit free exercise of the right to vote and registration and all sorts of ways in which you can participate in the electoral process. Section 5 was a provision that was initially supposed to be temporary. It was based on the fact that there were many jurisdictions that had a virulent history of voting discrimination, and those particular jurisdictions were then being subject to federal preclearance. They had to effectively show the federal government each time they were trying to enact a new voting change or law or practice, just to make sure that there wasn't going to be any continuation of that history of voting discrimination. It was a measure to make sure that these jurisdictions that found every possible way around the Constitution, around civil rights statutes, would not continue with those devious practices, those wily ways to continue to disenfranchise minority voters. We saw that even with the use of Section 5 over time, there was still continued discrimination. And so Congress extended Section 5. I'll fast forward to 2006. That was the most recent reauthorization based on a 15,000-page record in Congress. In 2013, the court took up this challenge to the constitutionality of that provision. And essentially the argument was that states, and they generally do, should have the freedom to determine the rules of their elections. They should be able to determine the time, place, and manner, and all the policies and practices attendant to elections. And while that is generally true, of course, when you have a history of discrimination, as we do in this country, there are ways in which Congress can also curb that freedom, and it is in tension at times with the guarantees under the 14th and 15th Amendments. So Congress enacted the Voting Rights Act for purposes of giving real life to the 14th and 15th Amendments, and Section 5 was a significant part of that. The court struck down Section 4B of the Voting Rights Act, and while we're talking a lot about Section 5, there's a reason I'm giving you all these statute references. Section 4B is really what animates Section 5. It's what we call the coverage formula. It decides which jurisdictions should be subject to that government preclearance, to that filter, if you will, that the government provides to make sure that discrimination is not happening. Once it struck down Section 4B, it left Section 5 effectively defunct and opened up the doors for jurisdictions across the country to then enact laws that had previously been determined to be discriminatory against minorities and to come up with even new devices and tactics that would suppress the minority vote. I'll just give you a few examples. Within hours of Section 5 being struck down, the Attorney General in Texas said that he would implement one of the most stringent photo ID laws in the country. And that photo ID law had already been determined to discriminate against blacks and minorities and Latinos in Texas. After that, we filed a case. We used Section 2, which is another provision of the Act that we've come to rely on even more in the wake of Shelby County. And most recently, in that lawsuit, a federal judge found that that same photo ID provision was not only discriminatory in its impact on minority voters, but that they intended to discriminate against minority voters. This is the type of law that we have now allowed jurisdictions to implement because there is no federal filter. Now, you might say, well, you brought a lawsuit and you were able to get that ruling that it was intentionally discriminatory. That cost a great deal of money. That also cost us an entire election. That photo ID provision went into effect during the time that we were litigating. The beauty of Section 5 is that it stopped discriminatory laws from going into effect before they could wreak havoc on an election and on a community. So that's just an overview of the case, and that's just a one example of many of the tactics that have been used across the country since the demise of Section 5. And we can talk more about ways to cure that.
And Wayne Dawkins, you look like you want to weigh in here.
Yeah, it's very brief because I'm not the lawyer on the panel. I'm a journalist or a reporter and editor. What has frustrated me about this was just about the case. It's just how I'm in the mass media business. So I am in the mass media business. So it's the idea of getting the word out to the public and really let them know that this is truly alarming because, in many media accounts, it wasn't so much that the Civil Rights Act was struck down by the court. It was gutted. I mean, it was basically if it were a car, you remove the engine and the four wheels, and you just have a shell sitting there that can't do anything. So, the lawyers know these details. They talk about Section 5 and Section 2 and everything, but it's important to get this in clear language to the average person to know what's going on.
Well, and if I could...
And I might add, because this has been an issue in the Deep South, but I wrote a biography of my mentor in Brooklyn. New York City was a Jim Crow city until the early 60s, okay? And 7 counties are still under the jurisdiction of the Voting Rights Act after it was challenged a year after it was passed by Andrew W. Cooper in Brooklyn. So it's everywhere, and it's in Latino areas, Asian American areas. There's mischief going on constantly.
And I'll just weigh in terms of getting the message out to the non-law literate public. Part of the fig leaf that the Supreme Court majority, 5-4 majority, used to cover what they were doing in Shelby County is, of course, as Janai said, it's what was struck down was Section 4, the actual coverage requirement. So the court said, Congress can just redo the coverage requirement. We're not stopping them. Of course, we know in today's Congress that the chance of that happening is about the same as the chance of the House of Representatives, having voted to repeal Obamacare 50 times, suddenly stand up and saluting it.
And I came at this kind of strident until I had to do my homework and read. Congress had been doing its job because they have been renewing it, but then we get this court decision, and it's a sucker punch.
Right.
And now we do have to go and ask them to go and fix this.
So there are some proposed fixes for Shelby County that I guess you would volunteer to tell us a little bit about that are out there, and what are their prospects? You, right.
Okay. Well, are we at the point where we can talk
yes.
about redistricting?
Uh-huh. Yeah.
Okay. And probably the reason why I was invited, I've been on this kick about we need to end this practice of politicians choosing their voters. Voters are supposed to choose their officials. And we need to go to nonpartisan redistricting. We have an egregious case going on right now in Virginia, in the 3rd Congressional District. We have a jewel of a representative, Robert Scott, who represents the district. He's the only black legislator of the 11 congressional seats. Does a wonderful job. But the problem is that in the last census, his district that's 53% black was made even blacker. Now, here's the mischief, because Virginia is one of the blackest states in the United States. 1 out of every 5 citizens in Virginia is African American. It is easily long time to have at least 2 districts, and here's a new term for you that's starting to gain traction. Not so much minority majority districts, but consider something called an opportunity district, where you don't carve a district necessarily to guarantee a person of color gets elected, because there really shouldn't necessarily be guaranteed. It should be the best person for the seat. But if the district is maybe in proportion, maybe 40% black or so, you can easily have another representative. This could easily happen in Southampton Roads area where I now live. But here's what happened. The district was made even blacker, and it's a strange district. It's on the line of the 28-sided district Attorney Gray talked about. And the court said, you gerrymandered. Go fix this. What the Virginia legislature did, and it's Republican controlled, they decided to stall, wait it out, because another case just went before the court, and they said, you know what, based on what they did with the Shelby case, they're going to probably rule in our favor. We won't have to deal with this. But what happened? The court actually said officials in Alabama erred. They're wrong on this one. So it came back, okay, Virginia, what you going to do about this? And the legislatures are still digging in. In fact, this week there was an editorial in the Virginian Pilot. They said not only are they thumbing their nose at it, they're making the taxpayers pay for it. Now, I'm in a room of lawyers. The pilot said it's costing taxpayers right now $300,000 in legal fees they shouldn't be paying, because they need to go fix this, and they can easily fix this. We need nonpartisan districts, and what happens, good government groups have come up with plans that make a lot of sense, and legislatures just smile and pat them on the head and say, very good, but we're not doing anything. But we need nonpartisan districts, and there are states that already have them.
So there, and some of those are hanging by a thread. Let me invite.
I can speak to some of the.
Yeah, there's this pending Supreme Court case on exactly such a district.
But also on the fixes. Oh, sorry. Speaking to some of the questions about the fixes for the Voting Rights Act and how we can address the Shelby County decision. So there has been the introduction of the Voting Rights Amendment Act, which was introduced last year and reintroduced in the new Congress. And some of the challenges with meeting the court's admonition to Congress to go back and look at the formula is that you're not going to get the same type of coverage today as you did in 1965 and in the subsequent reauthorizations of the Voting Rights Act. And you also have a public who wants to get back exactly what we lost. So we're looking at the Voting Rights Amendment Act, which would just cover 4 states instead of the 16 partial or totally covered states, and that's not a very popular solution. You're also looking at what was lost with the notice provisions of the Voting Rights Act. One of the very important things about Section 5 of the Voting Rights Act is that it offered a notice of which jurisdictions were conducting discriminatory voting changes. It gives citizens a chance to comment on that. It froze those discriminatory changes. As Janai mentioned, how do we get a notice, and how do we make that notice nationwide and not just limited to several jurisdictions? How do we strengthen the ability to have injunctions? We're now relying on Section 2 of the Voting Rights Act. It takes a long time to litigate Section 2 cases. We saw in Texas where we got a favorable outcome from the district court, and yet because the court was on appeal, the Supreme Court allowed the use of the voter ID during the last election. How do we strengthen Section 2? And also, how do we address last-minute changes that are likely to come up not just in the covered jurisdictions but across the country? And these are the issues that the Voting Rights Bar is putting forth and working on to try to get a Shelby fix.
And am I right, Marcia, that under Section 5, the covered jurisdiction had the burden of proof, of proving that the change wasn't made for the purpose of discrimination. But under Section 2, it's the plaintiffs that have the burden of proof, and that's where games are won or lost in court. So,
and the discriminatory change continues while the litigation is going on.
Let me ask Eric Rodriguez to address the nonpartisan redistricting commission issue that the Supreme Court may very shortly take a big whack at.
Well, first I just want to echo what has been said so far and note a couple things. First, the Voting Rights Act has been enormously successful. It really has over the years. And there's lots of instances of this. We're seeing, of course, greater representation in the Congress of African Americans, Latinos, and others. We're seeing much more elected officials all across the country. We're seeing voting numbers grow on the whole. So there's a lot to be thankful for, and that's why we're fighting so hard to protect it and expand it. The 2 things from a Latino perspective that are important to note was already mentioned or touched on slightly. I'm from right across the water here, from Red Hook, Brooklyn, and my parents are Puerto Rican. My father came to New York City when he was 15 and did not speak any English. As a result of that, he went to school. He went to school in Puerto Rico. He went to school here. But because he didn't know any English, at the time there was English literacy tests that were put in place. It was then Senator Robert Kennedy who proposed New York to be covered districts specifically for Puerto Ricans who did not know English. And that test was used over time to bar many Puerto Ricans from being able to vote in this city. So that was an important entry point. That was in 65, and then the legendary and honorable Barbara Jordan expanded minority and language access rights in 75 that broadened the coverage. And today, pre-Shelby, almost 40% of Latinos lived in covered districts and protected under the VRA in Section 5. And that's why it's so important to so many communities across the board. There is no question that from the perspective of redistricting, a nonpartisan solution is a much better solution than what we've seen out there. I think there's no question people look at the way the Congress is right. I, too, am not a lawyer. I am a policy advocate. I'm an advocate for civil and human rights for Latinos and immigrants. And there's no question that there is great political dysfunction in the Congress that can be attributed to real problems in redistricting. Now, are we going to find ourselves the political will in some ways to do a nonpartisan solution? I'm not so sure, but I know we've got to work toward that over time. And it is, look, it's a bipartisan problem. I certainly have had my fair share of conversations with Democrats in certain districts and Latino Democrats even in certain districts who really don't want more voters. I think they're perfectly comfortable with the voters they have and their constituents coming out at 20% or 25% and them winning time and time again. That's a problem, right? That's a fundamental problem. So if we want to see greater change, if we want to see increased civic participation, and I think we all do because that's good for our country and our democracy, we're going to have to try different solutions.
I'm optimistic, actually, because districts have become so politically polarized that voters are going to be fed up. And I'm looking from the perspective of the state I'm in. It's kind of funny. One party kind of controls the congressional districts, but about a third of the voters are independents. And as far as the recent governors are now U.S. senators, and they're of the other party, but the vote is a large block of voters that actually choose the best person for the job, regardless of party. So, let's break up these monarchies. People want these safe seats that they can just nest in and live forever. They need to do some work, and they need to work with different people of different social strata, race, and everything. That's going to actually mean that dirty word, compromise, actually reaching out to people you don't know that well. So it's an idea whose time has come. I think it's just a matter of time. So I'm optimistic something's going to have to give.
So does anybody want to talk to the pending Arizona case?
Yes,
just the background, as I understand it, is that Arizona, unlike the Northeast, is a referendum state. And so to get at this kind of polarization and politicization of the redistricting process, there was a voter referendum to take it away from the politicians and give it to a nonpartisan commission. And the state took a very dim view of this, and they challenged it as violating the state's constitutional entitlement to direct the time, place, and manner of elections. So,
I think one of the themes in voting rights today is when a case gets before the Supreme Court, you cringe a bit because there is this desire to address the issue of politicians choosing their own voters rather than the voters being able to choose their elected officials. And Arizona sought to do this through a commission process. And what's before the court right now is whether the legislature can cede its authority to a citizens' commission to redistrict rather than have the legislature do it itself. And redistricting commissions are one of the reforms that's very popular, and among citizens there's actually also going to be a referendum on the Ohio ballot this November to have a redistricting commission in Ohio. So the Supreme Court is going to be speaking to whether the state legislature whether the citizens can take the authority and the state legislature can have citizens adopt that authority to have a nonpartisan redistricting commission to get at this issue where there's this discontent of having a voice and being able to district and be able to elect who the citizens want rather than feeling helpless about their opportunities to elect who they would like to see in office.
Yeah, this case really, it's a very strange case in that it sort of pits the state political apparatus against the people of the state,
right.
With the Supreme Court being the referee. So this case will be decided within, this month. So watch that space. But just to broaden our lens a bit and talk about election administration, which this is part of in a way. Election administration can cover a multitude of sins, and I'll invite Myrna Pérez to talk a little bit about some of those issues.
Certainly. The question that was originally posed to me was what was the difference between election administration objectives and civil rights objectives? And I would posit that that's not a material difference in many instances, because as Attorney Gray noted, some of our most original baseline civil rights cases were about a person's ability to register to vote. So when we have a situation today where there are 50 million eligible unregistered Americans, a lot of them are unregistered because we make it a lot harder than it needs to be. A lot of them are unregistered because we have complicated and confusing rules that aren't obvious to people who don't have the time to study these kinds of things. And a lot of them are unregistered because people are making mistakes in election offices. That, to me, is a first-order civil rights issue. I think there are a number of ways to address this. The biggest and easiest way is to put more responsibility on the government to register our eligible Americans. We can do this by modernizing the way that we register voters. In many instances, we rely way too much on pen and paper for where we are in our technology. In most of the country, when you go to a DMV office to get your driver's license, if you're lucky, they'll ask you if you want to register to vote. If you say yes, they'll hand you another piece of paper, have you fill it out, and then what happens? All the forms have to get collected, they have to get bundled, they have to get to the election administration office, they have to get typed in. Those computers talk to each other. Most of the offices in the DMV have the kind of information that we need in order to determine whether or not you're an eligible person and whether or not you can vote. Doing things that streamline it so that the voter doesn't have to take all these extra steps will be cheaper, faster, and easier. And there has been some real momentum around the idea of using modern technology to benefit voters. One very popular example right now is online registration. We are seeing Democrats and Republicans alike supporting the idea of online registration. Voters want it. Makes it easier for election administrators. Clearly, there are some people in this country that still do not have access to computers. Paper is not going away, but it is a complement to registering people to vote that many voters will take advantage of when given the option. Another common reform that we see a lot is the idea of having computers in different offices do a better job connecting with each other. The state of Oregon did something that was really path-breaking just this legislative cycle, in which they voted to make the government's responsibility to register voters. So check this out. There's two cool components of what Oregon does. They are taking who is already in their DMV. So somebody who went into the DMV office to try and get a driver's license over the last 7 years, and at the time decided not to register to vote. They're looking at them. They're figuring out who is eligible, and they're putting them on the rolls unless that person affirmatively says, I don't want to. We expect that this is going to get between 300 and 400,000 people on the rolls in Oregon as soon as they decide to do it. Moving forward, they are going to register people and have the computer talk to each other. We're not going to be having this nonsense of foolishness of paper forms unless, again, the voter at some later point in time says, you know what, I don't want to be registered to vote. And they were very smart about doing things like checking with domestic violence advocates to make sure nobody's records accidentally got revealed. They're talking to immigrant groups about making sure that nobody who is a non-citizen actually accidentally gets put on the rolls. And we're seeing traction out about it. There were more than a dozen states that, after seeing what Oregon did, introduced legislation to try and get folks registered through a more automatic, more government responsibly held mechanism. I think all states should aspire to do it that way. I think we have way too many unregistered eligible Americans out there, and we need to do a better job of getting them on the rolls. Another really big reform that I think would be really important and would be really impactful is that of restoring voting rights to the nearly 4.5 million people who are living and working in our communities but cannot vote because they have a criminal conviction in their past. I am very, very discouraged and very, very upset because a couple weeks ago, a bill that the Brennan Center drafted that was passed through the Maryland legislature through the very hard work of the folks on the ground was vetoed by the governor. It would have made eligible about 40,000 folks in Maryland, many of whom are African American, and in a time where the tensions are what they are going on in Maryland, and that there are so many people that feel like they don't have a voice and they aren't heard, this seems particularly tone deaf. The good news about this is we have the votes right now for an override, so it is all of our responsibilities to put the feet to the fire of those legislators to make sure that when they come back in session that they do the right thing and they override. Attorney Gray talked about what happens when you are scared and being able to keep moving forward, notwithstanding getting a lot of incentive to stop. And I think the march and the struggle for voting rights is one that is so important that we cannot be discouraged, because we have some politicians that are trying to manipulate the rules of the game so that some people can participate and some people can't. We need to keep persevering, and we need to let them know that we're going to be holding them accountable when they try and suppress voters.
One discouraging thing that at least I see happening are states or jurisdictions that are abolishing or limiting the early voting. So you could vote before Election Day and not have to take time off from work and so on. That actually was expanding the number of people who were participating, but not the kind of people that these politicians wanted to have come to the polls. And so that's another issue that's out there. Janai, did you want to?
Yeah, just on that point alone, African Americans are one of the most frequent users of early voting. There are, I don't know if you have heard of Souls to the Polls. It's an effort that's used in many states, and particularly in the South, where congregations of people who worship at churches and different places are encouraged to go and vote as a group. It's a community effort. And it's one way to build community and one way to really build the force of voters in different jurisdictions, and to have them vote together and collectively in a way that makes them feel like proud citizens. And when you curtail early voting, you have a disparate impact on those communities. And if you look at the places where early voting has been curtailed, it's not an unsurprising correlation that they are predominantly black. I did want to just comment on the tension between election administration efforts and focusing on race-based remedies and efforts. And I agree with Myrna. I don't think that this is a zero-sum game, and I do think that election administration methods are extraordinarily important. I think that this is one of the instances where the rising tide does lift all boats. If we lift all boats, boats was a wonderful slip up there. But the rising tide does really lift all boats, in that if we make voting more accessible to everyone, that is certainly going to help African Americans and Latinos and Asian Americans and Indigenous Americans and others who have been traditionally and historically excluded. I do just want to caution us, as Fred Gray did early on in his remarks, that we really have not, in any way, shape, or form, won the war against racism. We still have a very long way to go, and we still need laws and tools and mechanisms that expressly address that issue, that allow us to bring race-based claims, that allow us to address racism in all of its nuances, including the implicit bias, the unconscious bias that goes into many of the decisions that we see today and the impact that they have on minority communities. So I would certainly like to see us continue to improve the administration of our elections while not losing sight of the large chasm that still exists and cleaves on racial lines.
And if I could just comment briefly on the early voting part, what I want the audience to leave with is a recognition that this cutback is relatively new. For a very long period of time, when you had early voting legislation in the state, it was to create it, it was to expand it, it was to make it more accessible, and that changed basically around 2010. The courthouses, the state houses compositions changed. Mm-hmm. We saw a wave of restrictive legislation all across the country. We saw our cutbacks to early voting. One of the things that I think is very encouraging, and I think it's always important to leave these things on an encouraging note, is we are seeing a slowdown of the restrictions In the last 3 years, there have been more laws that have been passed in the state houses that would expand the right to vote than would constrict the right to vote. Now, that doesn't mean voters are better off than they were, because so much damage was done, and the laws that have been constricting the right to vote are very, 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 very severe. But we are seeing, at least thus far, a slowdown of some of the restrictions, and I think it's because there are organizations like on this panel, there are journalists like people in this room, there are voters like people like you who are standing up to the politicians and saying, we don't want you mucking around with our right to vote. This is something that is very American to make our elections free, fair, and accessible.
I want to give Marcia a chance to talk about something that she informed me of that I hadn't been aware of, which is another cynical move, which is to consolidate or move precincts in a way that really makes it very difficult for people to keep track of where they're supposed to vote and how to get there and so on.
Yeah, so we've been working with jurisdictions in Georgia. We found out from the citizens, and this is again where notice is important and citizens are aware and engaged about what election officials are doing very early, about the move in the state to consolidate precincts. And so, for example, in Macon-Bibb County, there was a move to consolidate precincts where they focused on the African-American precincts and were consolidating the precincts such that the African-American precincts would have 5,000 to 6,000 voters in a single precinct. And they were not doing this for the predominantly white precincts. And the community became aware of this and inquired about the basis for the consolidation and how the city would move forward in administering a precinct of 5,000 people, and why the disparities between the African-American precincts and the white precincts. And we've been engaged in meetings where the community has, there's now a Citizens Advisory Committee that has been working with the board to hold them accountable for a decision to consolidate the precincts, and this is ongoing. In another county in Georgia, the decision was made just to have one precinct at the county seat. And where do African Americans live? Tens of miles away from the county seat, in a county where there's no public transportation to get to the county seat to vote. And this process, again, has been frozen. But what this is indicative of is without Section 5 of the Voting Rights Act, where before these counties would have to submit this change and the burden placed on them to show why, that it was not discriminatory. Without Section 5 in action, we need to be vigilant about these type of activities that are happening, and organizations here on the panel are working with communities to empower citizens so that they can push back when these things are occurring.
So as you explained it to me, in the absence of law, you've got community organizing of the good old-fashioned kind to get people to push back against this. We're almost out of time, but yes, sure.
I just want to throw in quickly one more constituency to protect. Yes, we should restore felon rights. We should not make it a burden for elderly folk living in rural areas. But let's add college students, too, because Hampton's a national university. We draw students from 40-some states, and roadblocks are thrown in their path to keep them from voting. And often we complain young people are not, they don't get involved in these things. They don't do their civic duty. Well, a lot of them are. I have some students on election day, they may drive to Richmond or to North Carolina to vote because their family, their elders hold them accountable. In other areas, a previous job, Prairie View A&M in Texas, there was some scheme to keep the campus from voting until the elements of the media called them out. So that's another constituency.
Right. Do we have time for a question or two? You're my timekeeper. Yes? Is that a yes? Okay, so there is a microphone. I guess we have a few minutes. Hold the mic real up to your mouth, really.
My question, number one, when we see such apathy in voting overall, when I think about the last midterm election, how are we going to inspire people to, number one, be focused on the Voting Rights Act if they're not actively voting, number one? And then number two, I'm wondering, from a corporate perspective, we use big data a lot. So I'm wondering if big data, or how big data is used in addressing the issue as an argument. And then lastly, I wanted to add one thing, which when you're talking about college students, it's a great opportunity to increase their opportunities for voting, is to add it to the FAFSA form, just like at the driver's license, because they ask if you're registered in service, but you can also ask, are you registered to vote?
Anybody want to take these?
I can address a couple of those. I mean, I think that's absolutely right. The right to vote is extremely important, but what about the will to vote, and what are we doing to address that? And I would say, look, a lot of organizations that we work with spend time on voter education work, quite frankly, and making sure that those that are out there that are either unregistered and or registered but not turning out in regular numbers understand what's at stake. And how can we contribute to that? I would say a lot of that, certainly in the nonpartisan, nonprofit civil rights space, is not well resourced, but it's certainly work that we believe is important. And elections do have consequences. We have very clear examples. When Latinos in 2010 were credited as being the firewall and protecting the Senate for the Democratic Party, immediately they came back, adjourned or convened, and voted on the DREAM Act. And the majority of the Senate approved the DREAM Act. That was important to eventually getting deferred action. When Latinos were credited with contributing to a second term for the Obama administration, immediately, and Republicans became really concerned about only securing 27% of the Latino vote in the 2012 election. Immediately they came back and they passed comprehensive immigration reform in the Senate, something that we have been working on for over 2.5 decades. And so elections, voting, influences and changes minds. And it's up to many of us to be able to educate our folks in our communities about just how that happens. Now, on big data, a lot of the organizations that do voter registration and GOTV work rely heavily on data systems to be able to identify areas where we need to do registration work and get out the vote work in races. So big data is important in terms of creating systems and being able to track and monitor behavior to the extent that we can, and make sure that we're getting information into the hands of would-be voters.
And two really quick things I just wanted to mention. We talk a lot about the problems in voting, and that could be discouraging, and we also need to focus on empowering and having that balance between lifting up wrongdoing, but also empowering voters and not having them feel discouraged with a message of here's how they're trying to keep you from voting, and that's a challenge we have in the community, and we've been doing research on that. And then on data, data is, it drives a lot of the work that we do in our litigation, in our outreach, in making the case in advocacy. It's a very important part of the work, both in showing the impact of laws. Since right now we're not dealing with you can't vote because you're a minority, we have to show how laws that are being proposed can have a disparate impact on minorities, and use data a lot to make that case.
Myrna, did you have a comment?
Yeah, I did. I'm a data person, so I look at a lot of the research, and I know that from a research statistical basis, there is a lot of people that don't participate that can, but those are not the voters I meet. I don't meet apathetic voters. I meet people who are returning citizens who are desperate to be able to show their children that notwithstanding whatever screw-up they did that caused them to go into prison, that they want to be able to contribute something. But there is a Jim Crow era law that is preventing them to vote because they have a criminal conviction in their past. I meet people like in our Texas case, like Miss Sammy Louise Bates, who had been a longtime voter. She actually even helped her grandmother count out the pennies for her poll tax. Voting is incredibly important to her, and she had to go through a Byzantine, nightmarish effort to try and get a birth certificate in another state when she didn't have the money to make sure that her family had food for the month, and she went to the trouble and she persevered. And so one of the ways that we are trying to do to get people not to be apathetic is to highlight these heroes, to let people know exactly how many people in this country are willing to go to the trouble and the sometimes shocking, horrific, but very inspiring amount of trouble that they're willing to do to exercise their right to vote. And every time I encounter a kid who is not sure that they think voting matters, I introduce them to one of these people. You can find stories of these people on the Brennan Center website. We make it a practice of trying to identify them and to lift them up and to have them inspire people, but we need to tell the stories of how important the right to vote is and how much trouble people are willing to go to, and we need to be very clear that being able to drive 2 miles each way to a DMV office in order to get an ID is not a precondition for the right to vote.
Maybe the last question.
I just have a real quick question.
Yeah, you got to hold the mic up to your mouth, actually.
Can you hear me now?
Like, hold it.
Can you hear me now?
A little bit.
Can you hear me now?
Yeah.
Okay. My question is this. We're talking about voting. We're talking about the Voting Rights Act, and we're talking about people getting out to vote. But in the interim, we had Citizens United that came in, that pumped all this money out there, that is actually trying to keep people voting in a particular block. So in order to get us to get the voting rights the way that we wanted the 4A and B and Section 5 back, how do we also attack Citizens United? Because that money's being thrown out to get particular people to vote. Gerrymandering has been going on since the 1700s. So, it started in Massachusetts and kept going. I don't think gerrymandering is ever going to go away. So how do we tackle big money being thrown out on both sides, because both sides are doing it, and use that money or figure out how to take that and put it back in so that people are voting and it's being used in the correct way?
So I think that's, when we talk about voter apathy, no doubt it exists, but I agree that it's not as widespread as people like to say it is. We've seen so many elections where turnout was robust and enthusiastic and inspiring to know that when people feel that they have something to vote for, they do turn out. But one of the issues that often comes up when people talk about their negative feelings toward elections is that big money plays such a significant role. And one of the ways in which you can begin to combat that, we are faced with Citizens United, which is a significant obstacle on the federal level, but there are many state initiatives that can help improve the equity in funding for candidates, which can then provide a slate of candidates that can be more appealing and inspiring and reflective of the communities that they hope to serve. So that's certainly one angle. Also, we need to be thinking about supporting more public financing of elections. And that is a critical point if we want to level the playing field for new people and hopefully young people to start to enter into politics, enter into the electoral arena. And we have so much promise in the movements that we see developing today, the Black Lives Matter movement, and many of the young leaders who are coming out of that, and not only relying on them to agitate from the outside, but inviting them to agitate on the inside and to do it in a way that is affordable and possible. And the way to do that is to enable public financing of elections.
I think that's a good note to end on. But before we end, I've been asked to, and I'm happy to point out Fred Gray's book, Bus Ride to Justice, Revised Edition, Changing the System by the System, just out last year, I guess. 60 years of law practice, 1954 to 2014. So book is available at your local bookstore, I guess, and on Amazon, and outside. Okay, great. So I've learned a lot, and thank you very much.